All right. Hello, everyone. Thank you for joining us today for our Partnering for Success webinar on building awareness to prevent EPLI claims. Leading today's webinar will be Ryan Simmons. Ryan joined Farrar Bates Berexa in 2019. In his practice, he focuses on municipal law, employment discrimination and retaliation, general tort liability, municipal liability, and trial and appellate litigation. Ryan possesses a strong understanding of cases involving FLSA, FMLA, discrimination, and whistleblower claims. Prior to joining the firm, Ryan was an associate attorney at the Employment and Consumer Law Group in Nashville. He effectively resolved numerous employment claims through mediation and private settlement negotiations and aided in the development and drafting of employment policies for local businesses to comply with applicable regulations and laws. Ryan earned his Doctor of Jurisprudence in 2012 from the University of Denver Sturm College of Law in Denver, Colorado. He graduated magna cum laude from Lipscomb University, where he earned his Bachelor of Arts in Psychology in 2008. While at Lipscomb, he studied abroad in Vienna, Austria, and London. A Nashville native, Ryan enjoys traveling the world with his family in tow and enjoys skiing, hiking, and biking. And with that, I will pass it off to Ryan.
Great. Thanks, Amber. So as Amber mentioned, I previously used to work for a different firm. And in doing so, I was actually doing a lot of plaintiff's employment law. And so as a result of that, I kind of been able to see both sides, how these claims typically come up and how they are approached from both sides, both from the employee side and the employer side of things. And so I feel like that kind of gives me a little bit of an inside information as to how these things typically play out. Handled quite a few of these at this point, so I'm able to at least kind of I always see something new, but I feel like I'm always able to go through and at least forecast where the issues may be. And so that kind of brings us a little bit to today. And so usually when I start these things, I give that preface, and I usually provide the warning. I may have sued you or somebody you work for, so don't hold that against me. But that being said, I try to at least use that in my practice now, to at least use it to a benefit to help employer side of things. Today's focus is going to be more on employment claims and how I feel like maybe some general awareness can be helpful in either preventing these claims from turning into like a full-blown litigation case down the road, or at least potentially giving an employee maybe second thoughts on whether or not they need to file suit. Oftentimes, when a plaintiff is filing a suit, it can be based on a number of reasons. And so maybe kind of pointing some of these things out and hopefully trying to prevent some of the motivating factors may go at least a little ways in trying to prevent some of these claims. I think it's important for all employees, no matter if you're in HR, risk management, supervisory capacity, all the way down to just a typical hourly worker, to be aware of some of these things. And so what each employee may need to be aware of, it's going to depend on their role. I don't expect an employee who may be working in some sort of public works capacity to be able to speak to the ins and outs of every employment law. However, it's going to be important for that person to know who to go to for certain things. And similarly, they're going to need to know exactly what should or shouldn't be done with their coworkers. With HR employees, they need to know the ins and outs of employment claims, maybe not to the same degree that somebody may be handling them in litigation. That being said, it's important to know potentially what boxes need to be checked for these claims to arise. I will say, HR employees play a pivotal role in these types of claims, but these HR employees are also going to be relying upon others, including first-line managers, in trying to figure out how do we need to respond to a certain situation? What do we need to do? What's the situation? Similarly, supervisors need to be at least more aware about certain aspects like their communication with employees. Supervisors are often the first line of risk when you're talking about these claims. And so that's typically who an employee may be kind of setting their sights on, is how they were treated by a supervisor. My hope is, at least with this talk, is to provide some examples of maybe what to do and what not to do, to help provide at least the impact of how these things can arise. I, I don't know that there are going to be too many hard and fast rules that I give today that are just going to go through and be kind of the silver bullet for these things. I think it's important to know that these are often a balancing act. And so not everything's going to be applicable all the time, or there may be some sort of double-edged sword aspect to something, to where if you go to one end of things, that may almost be a little too counterproductive, to where you're not taking into account certain facts or certain circumstances otherwise. Um, and I will be candid too. There are some, at least selfish reasons for giving this talk today. I usually get retained once somebody has gone through and filed an EEOC charge or some sort of lawsuit alleging an employment claim. And because I'm often brought in on the back end to defend these things, I have the advantage of at least being able to play Monday morning quarterback. I can maybe point to things that could be or should have been maybe done differently. So really what I'm trying to do is maybe make my job a little easier down the road if I'm having to defend a claim. I want to set myself up for success, but two, I want to make sure that everybody else is set up for success as well. I have no doubts that even if I were to give the perfect information, there's still going to be employment claims. So I don't know that anything that I say is going to go through and definitively prevent anything from happening, but I'm hoping that it'll at least raise some sort of awareness as it relates to things. Because from your end, from the employer side of things, avoiding these types of claims are going to go through and save money, time, resources for you and your employees. It's not uncommon for these types of claims to be a six-figure settlement, unfortunately. The damages can be dependent on the various types of claims. Typically, when you're dealing with like a wrongful termination claim, you may be looking at an amount of pay that somebody feels like they're entitled to because they got terminated. But one of the other things to take into account is oftentimes these employment claims will allow for plaintiffs to receive their attorney's fees. That's built into the statute. The statute goes through and provides for that. And so that can very quickly cause these costs to rise, and they often have to be accounted for within these settlements. So I'm sure, as you can imagine, not only accounting for somebody's lost wages, but also their attorney's fees, which are not cheap, unfortunately, that can very quickly amount to a very costly claim. And so the hope is to at least reduce those, or at least reduce the number of them. And one other important thing to think about too is, even though there may be some sort of bogus claims or a claim that doesn't necessarily have much of any merit, there's still a cost to that. There's still a cost of having to retain our firm to go through and defend that, or at least from your end, that the time and effort that it takes to gather documentation for us to defend the claims. So these claims are always, like I said, come with some sort of cost, whether that's time, money, energy, stress. I know they're not fun. It's probably not on anybody's bucket list to go through and to have been sued at some point for some of these claims. So they can be very personally stressful. So hopefully, kind of pointing out some of these issues may avoid some of the problems. I would say you'd be very surprised how quickly some of these things can domino. So what's more expensive than an employment claim? Not knowing it's coming. So again, the awareness here can go through and to at least alleviate some of these issues. Being aware of these potential claims and how they come about can go a long way in trying to prevent these, and also trying to minimize any of the impact down the road. Again, depending on what your role may be, it may vary about the level of awareness. I feel like those in HR or higher up in administration are probably going to need to have a little bit more awareness about the specific types of claims. Supervisors, it's important for them to be aware for maybe keywords like I need an accommodation, I need leave, those types of things. And then similarly for employees, whether full-time, part-time, they're going to need to know kind of, all right, how do we act around other employees? What's permissible? What are the policies that I need to follow? Those types of things. So it's going to depend based on their role and what they may need to know. As an employment attorney, I often have to think about cases in terms of what kind of claims somebody may bring. And like I said, having been a plaintiff's attorney, I put myself in the employee's shoes and usually try to describe any type of claim as being some sort of, I guess, continuum or some sort of color gradient scale. It's kind of the most easy way to describe it. And one of the things I usually tell people, I try to evaluate claims kind of on a scale from black to white. And as you can see here, there are a number of shades of gray. On one end of the spectrum, it's say where there's no color at all. There may be, I equate that to there not being any claim whatsoever, at least not a viable claim. And so oftentimes once facts arise, you can kind of tell that towards the other end of the spectrum to where maybe the 10 might be, all right, there's full liability. There is no question that the employer is liable for some sort of claim. It's not often I get either a 1 or a 10. It's always somewhere in between. There's always some sort of shade of gray. My goal is to go through and to try and paint that picture to be maybe towards one end of the spectrum, towards the one end of the spectrum, and the plaintiff's attorney maybe to paint that picture on the 10 side of the spectrum by adding in color, details, facts that kind of help to paint a different picture. And so we each kind of have the same role. We're just trying to paint with different colors. So as an example, I had a case when I was working as a plaintiff's attorney, and I may kind of give two different snippets. You can kind of see exactly how this may work when I'm evaluating a claim. The two different perspectives. This is the same case. The employer, I think it was a call center for some sort of telecommunications company, ended up terminating an employee who I think was some sort of call center representative. I think he had moved his way up. But regardless, they terminated the employee for taking an item from the self checkout stand in the break room area. There's like a self checkout that employees could use to scan snacks. They have to pay for them, and then they could use it. They could go through and eat those on their break. So here the employer had gone through and terminated the employee for taking an item without paying for it, and it was recorded on video. That seems pretty clear cut. Like, okay, then employer can go through and let somebody go for that, right? Seemingly no issue. The flip side of that is, and my clients let us know that he was a long-term employee, he'd been promoted multiple times. He had actually shortly before his termination complained about race discrimination that was ongoing, and the employer had let him go for taking essentially a dollar snack. It was $1.09. Subsequently, we found out the employee, even though he had walked off and the recording of him leaving the area with the item ended, he came back and paid for it, and he had a receipt. So we ended up getting the receipt, and obviously that was a big part of our case, just showing that he'd actually paid for it, that the employer had gone through and let him go, even though he had paid for it. Even if he had walked off, he came back with it just out of a lack of awareness of kind of what he was doing. He's just kind of walking around. Come to find out during the litigation, there were over 41 incidents of theft, and our client was the only one that was disciplined. And he was, like I said, he was disciplined shortly after complaining about some sort of race discrimination. So you can very easily see kind of the differences between one side of the case, how it's viewed, and the other side. And by adding all of those facts very quickly, you see that these claims can be shades of gray. So it's not always very easy to go through and to say, all right, is somebody going to win a case or not? Because there's always some sort of facts there that go through and identify, well, it's not so easy. May not be quite as easy to go through and figure out. So similarly, usually in these cases, there's often multiple claims. It's not just one. You're not just looking at, okay, is there a retaliation claim? It's often coupled with, is there some sort of race discrimination claim? So I'm evaluating each of the claims kind of on these scales to figure out, all right, which ones give me pause, which ones give me worry, but which ones have evidence that would go through and support some other finding than maybe what's been presented or looked at by somebody. One other thing that's kind of important to note that I will say, kind of having represented both sides of things, in each of these cases, each side's going to be telling a story. So with that example of the self-checkout stand and the termination there, the employer's story was cut and dry. The employee took the item, didn't pay for it. We let him go. We let him go based on that reason. It wasn't based on anything else. The story for the employee provides much more color to show, okay, this is not just some employee going through and taking an item or stealing an item. He had gone through and it looked like on the surveillance recording, the video recording, that he had just walked out of the screen, but he ended up having a receipt for the item. And so we then questioned the employer as far as, did you look at this into much detail, or were you just looking for some sort of reason to let him go? And so each side is trying to tell a story, and those stories can be more believable and more memorable when you can connect better, like on a personal level. So by identifying that this employee had a long track record, even promoted multiple times, he actually had a young daughter he was caring for at home that had some sort of illness. So when you have those details to go through and connect on a level, you're going to have certain themes that may arise. And so oftentimes, I guess plaintiffs and defendants, but plaintiffs particularly, may try and frame a case in the light of a supervisor maybe being a bad guy, or trying to go through and to connect that with taking some sort of discriminatory action. So by being aware that somebody may go through and attempt to paint somebody in a bad light, if you've got an employee who's actually not a bad guy and there's no evidence of it, that's going to be much easier to go through and defend. And an employee is not going to be able to go through and to really make that connection to where everybody says, actually, we love this guy as a manager. We would do anything for him. So it's much easier to go through and to kind of unknowingly create some sort of defense without really having to do so, just based on the facts. A complaint or a lawsuit may go through and describe a supervisor as, yelling or being angry, micromanaging, making snarky comments. When you have set the scene with a bad guy or a bad actor, it's much easier for somebody to go through and to believe that some sort of action was discriminatory or improper if they terminate somebody. So when an employee can show that an employer is either inconsistent, biased, maybe he's a poor communicator, or there's some sort of toxic work culture, it's going to be much easier to create a link to some sort of illegal conduct. So those things in and of themselves may not necessarily be actionable. There may not necessarily be some sort of employment claim just because somebody is inconsistent or an employer may be, a poor communicator. That they can be tied together, and it's important to understand that oftentimes these themes are painted with these lawsuits or these claims to where it's painted with a broad brush that a certain employer may be inconsistent with its actions. And so as a result of that, because they're inconsistent or because they may be, bad communicator, then there is some sort of illegal conduct that comes along with that. So these are kind of my 4 C's for today. I think there are a number of things we could have gone through and identified, but these are some of the things I feel like I've kind of identified throughout my practice over these years. I think it's important for employers to be aware of what claims are, kind of knowing what to do and what not to do. It's important to obviously have consistency. You want to make sure that the employer is acting consistently towards these employees. You also want to make sure there's good communication. I've found that in my practice, it seems like most plaintiffs, employment plaintiffs, good communication can go through and oftentimes have corrected some sort of decision that was made by the employee to then file suit. Miscommunication is one of the leading kind of motivators for why people go through and file suit, because they may think one thing to where the reality is another thing. And then finally, culture. It's important to have a good culture. Obviously, happy employees aren't generally looking to sue people. So if you are employing happy people, then the hope is you're not going to have too many employment claims. So that when I say claims, I am looking at, all right, what type of actions can an employee potentially go through and assert? So it's important to be aware about what the possible claims are and when they may pop up, so that way you can help prevent them. So being aware of what's out there can help you kind of look for the red flags for these types of claims when they are asserted. So one of the, obviously the most prevalent claims that I see, it would be discrimination cases. And so that's typically covered by Title VII. And so that prohibits race, sex, disability, age, religion, national origin discrimination. And there's different ways to go through and to assert those types of claims. One of which that we see very often involves disparate treatment. So essentially, an individual in one group is claiming that he or she is treated differently than members of another class. So a female may go through and say, well, I was treated differently than a group of male employees, or um, somebody in one protected class, an older individual may go through and say, well, I was treated differently than the younger employees. So those kind of comparing and contrasting of different types of treatment, that is a big kind of issue to be aware of in terms of what claims are out there. Disparate impact, we don't see that too often, but it's when a facially neutral policy has been or has a disproportionate impact on a protected class, even when there's not any intent. So if there's a specific rule that goes through and disproportionately impacts a certain group of people, there can be a disparate impact claim. It's just important to be aware maybe how some of these policies do end up impacting different individuals. Similarly, harassment claims are very prevalent. So I would say one of the most commonly misunderstood claims is a hostile work environment claim. You may hear that from employees where they threaten or they believe they've been involved in a hostile work environment claim. It's typically not the case. It usually requires quite a bit of, I'd say, pretty bad conduct to go through to actually constitute a hostile work environment. Usually there's going to be some sort of like racist or sexist jokes. The harassment actually has to be based on some sort of legally protected characteristic. So when somebody says they're experiencing a hostile work environment just because their boss may have been mean to them, that's not necessarily going to go through and be enough to establish a hostile work environment. The conduct has to be based on somebody's status in a protected class. So if that conduct is based on somebody being a woman, or somebody being Black, or somebody being older, or somebody being disabled, that's when the hostile work environment can come in. Usually, you're going to be looking to different factors to see, all right, was there some sort of inappropriate touching, inappropriate comments? There may be some sort of bullying involved because of somebody's disability or religion. Like I mentioned earlier, there may be some sort of sexual comments involved, pictures, unwanted flirting. All of those facts can kind of come about with a hostile work environment claim. So it's important to be aware, all right, if these things are happening, how do we go through and how do we address them? Because they need to be addressed quickly. And they can be, like I mentioned earlier, that's not necessarily somebody getting mad at one another. It usually has to be either severe or pervasive. So what exactly does that mean? So severity, you're usually looking, is there something that may be physically intruding? If you're dealing with some sort of like physical touching, that's going to be much more likely to be severe or pervasive than some sort of one-off comment about something. Similarly, if something is either severe or pervasive, you're going to be checking to see, all right, is this occurring frequently? Is this going to be pervasive in some sort of employment context each day in an employee's work environment? That one of the other things to recognize is this is often judged from a reasonable person standard. So where you may have somebody that's maybe a little too sensitive and they have alleged a hostile work environment, their sensitivity is not necessarily the measure for whether there actually is a hostile work environment. It's going to be a reasonable person standard. And so case law is usually going to go through and dictate what happens in those circumstances and whether or not it rises to the level of an official hostile work environment. One of the biggest questions I usually get when I'm looking at these types of claims is whether the conduct rises to actually being severe or pervasive. So I've had cases involving physical intrusion by employees, cases involving, female employees being groped or touched by male employees. But one of the cases I handled from the plaintiff side of things, I represented I believe she worked at a residential youth home, and she was essentially some sort of advisor or maybe counselor for some troubled youth. And so she had worked in close proximity to a male coworker, and at some point she had been touched by the male coworker. So it occurred once, it wasn't witnessed by anybody, but she then reported it. And so unfortunately, the employer did not necessarily take any action once it was reported. It seemed like the employer couldn't necessarily substantiate whether or not it happened. It was a he said, she said type deal. Problem was there was not necessarily any measures taken to separate the employees. And so the male employee did it another time. However, this time it was recorded on video. And so the male employee had essentially groped the female employee. And like I said, it was recorded on video. Obviously, at that point in time, it was unquestionable what took place. There was some sort of severe or pervasive conduct that would constitute enough to be a hostile work environment. And so my client, the plaintiff, ended up filing suit. And as you can imagine, that resulted in a very quick settlement. It was a six-figure settlement. We had obviously very clear evidence that something took place. And it seemed pretty obvious from the employer's perspective that they were not necessarily going through and going to fight it given the facts. And so when these red flags appear, like maybe an employee saying, okay, well, this happened, I was touched by this employee, to whatever extent you can in that type of situation, it's important to separate those employees so that way there's not necessarily any possibility of that happening again. Because once it does happen again, it can be very costly. Another one of the cases that I handled was this was on the defense side, but had a male employee that became a little too touchy with the female employee, began giving the employee hugs every day at work when she showed up. And there was a pretty big age disparity there. The male was older, the female was very younger, very young. And so over time, these hugs every day became a little bit worse and worse. The male's hands began to wander over the course of time, began to touch her back, touch the female's side. He eventually moved to kissing the employee on the cheek. At some point, the young female eventually complained. And once the case moved to litigation, we tried to argue that the touching was not necessarily bad enough to constitute an objectively hostile work environment. But the court looked at several different factors that the plaintiff had said happened, was that this took place over an extended period of time and that there was some sort of physical touching involved. So those were factors that the court went through and looked at to say, all right, this is going to be potentially a hostile work environment. We ended up resolving the case shortly thereafter, in part due to those factors the court looked at. Another one of the cases I handled involving a sexual harassment, a hostile work environment claim, involved the exchange of nude photographs of female employees by male employees. So these male employees would either solicit or receive nude photographs of females and then pass them along to other male employees. In that case, we didn't necessarily make it far enough for there to have been any ruling on what the court would have decided, but I don't have any doubts that the court would have found it to be either severe or pervasive to constitute a hostile work environment. So when those types of things arise, it's important for an employer to become obviously aware to put it to a stop. One other kind of weird instance of which I've had involving hostile work environment claims. I had a couple of cases involving foot fetishes, and that's obviously not something I would have on my employment law bingo card, but apparently it comes up. I see a wide variety of claims, and so for whatever reason, we have had a couple of cases involving foot fetishes. And so I have no doubt that if those cases were to proceed to a court looking at them, that it would pose potential issues for sexual harassment claims. In one instance, there was an employee who admittedly had a fascination with feet. I don't think he described it as a fetish necessarily, but he took a liking to a female coworker's feet, and the female ended up obviously complaining about it. And so as part of that, there was, I believe, an EEOC charge that was filed, and we ended up arguing that foot fetishes are not necessarily inherently based upon sex, and so there would not necessarily have been an action that was based upon the individual sex. There's not necessarily been any official ruling on that, but I don't enjoy having to be put in that situation to try and argue that a foot fetish is not necessarily based upon sex. I'd much rather have a different argument to be made, but sometimes you have to make the arguments you're dealt. The other type of harassment claim is a quid pro quo, typically this for that type situation, where a supervisor may demand some sort of sexual favors or romantic attention in exchange for a raise, a promotion, avoiding termination or demotion. Obviously, those can pose major issues, and it's important to be aware if those situations are ongoing to put a stop to them. Wage and hour claims, it's important to be aware that these do pop up. And one of the important things to be aware about is sometimes these can be costly because they are not usually covered under EPLI policies, insurance policies. And so employers can sometimes end up having to pay out of pocket for these. So it's important to kind of audit how employees are being paid, whether or not they are working off the clock, and whether or not they've been potentially misclassified. Some of the other claims of which to be aware is that sometimes there can be claims for failure to accommodate some sort of disability where it's been requested, or to accommodate a pregnancy. That is one of the newer employment laws, is they have codified that pregnancies should be accommodated, or some sort of issues related to pregnancy need to be accommodated under one of the newer federal laws. Important to be aware about that. And similarly, we see sometimes claims that pop up when leave is not necessarily provided by an employee, like under the FMLA, where an employee may be entitled to leave and the employer does not necessarily provide it. Similarly, we see sometimes constitutional claims as public employers. It's important to be aware that there are some additional restrictions that have been placed on employees given that fact. It's oftentimes see First Amendment issues that pop up. Sometimes it will focus on speech maybe outside the employee's duties. And in those circumstances, that's when a First Amendment claim can arise. Usually there is some ability to go through and to discipline an employee if the speech arises in the course and scope of an employee's job duties. But when you've got an employee going home and posting on social media about some sort of issue that may be a public concern on their time off, it's important for an employer not necessarily to go through and to discipline an employee based on that speech in and of itself, because that's when a First Amendment claim can arise. And then one of the other most popular or most prevalent claims I typically see in my practice are retaliation claims. So this is when an employee will engage in some sort of protected activity and then they experience an adverse employment action. So, all right, what's the protected activity that qualifies there? Usually it's a complaint about discrimination or harassment or some sort of reporting of illegal activity. This is when an employee engages in some sort of opposition to maybe an action by the employer. And so, coupled with that, after an employee may engage in protected activity, if there's an adverse employment action that takes place shortly thereafter, like a termination or a demotion, that's where an employee can go through and assert a retaliation claim because they are looking to see, all right, was there some sort of causal connection between the employee's complaint and what happened to them afterwards? Obviously, as you can tell, it often comes down to why something happened, why an event took place, why an employee was terminated, and there's usually varying points of view as far as why those took place. So when do we see these claims, or like what circumstances do we see these claims arise? I would say the vast majority is when somebody's terminated. So whenever somebody is being terminated, it's important to have all of those ducks in a row to make sure that, all right, the reason we're letting this person go is based on a valid reason. It's not necessarily something that is impermissible. And even if it's not necessarily based on an impermissible reason, it's also important to understand that a plaintiff's employment attorney is probably going to try and frame it in some sort of impermissible reason. And so it's just a question of what kind of evidence can they use to establish or to assert that maybe they were let go for discriminatory reasons. Are they looking at some sort of inconsistent treatment? Are they looking at something that maybe didn't end up actually happening? So it's just important to kind of have those facts lined up and to have those reasons documented when somebody is let go, because that's most often when we see it arise. Similarly, if there's been some sort of denial of a request for an accommodation or any type of harassment when an employee is employed, obviously those claims can arise then as well. So in terms of claims, again, it's important to be aware of what the claims are out there, just so that way you kind of know, all right, this may be coming down the road. If it's coming down the road, you need to be able to address the risks that are there. And if you don't know that it's coming, you can't necessarily address them. Like I said earlier, employment claims usually follow a pattern. And so the pattern they may follow is, all right, was there some sort of inconsistent treatment? Was this employee but were they treated differently than somebody else? So there may be some comparing and contrasting there. Knowing what an employee may go through and say, or why they feel like they were not actually terminated for valid reasons, that can be helpful to know down the road, at least for an attorney or for whoever who may be responding to some sort of claim that actually arises. So by being aware, okay, this may be coming down the road, that way some of these issues can be better documented. So that way, you know exactly, all right, what are the red flags here? One thing that I will say is one of the red flags that usually pops up for some of these claims, it's important to be aware that if an employee does go through and complain about something, then they may be seeking to establish some sort of retaliation claim. Complaints may come when there's handwriting on the wall that an employee may be terminated. The employee may be trying to establish some sort of protection, maybe trying to set up some sort of retaliation claim. I've seen people file EEOC charges while they're still employed, knowing they may be let go soon with the hopes that's going to go through and protect them. And two, it's also important to be aware that oftentimes employees may go through and seek some sort of medical leave or some other type of protection when their job performance may be lacking. I've had cases where it's very clear and obvious that an attorney has drafted an employee's complaint. So if you get an email from somebody complaining about something, you may notice that the employee's writing may have become free of grammatical errors or uses very different language structure than they typically use. That's typically a pretty big red flag. Okay, there may be a retaliation claim coming down the road if somebody gets fired. So just be aware that all the ducks are in a row when somebody is let go and that they're let go for valid reasons. So this is the second C here, consistency. It's important for employers to be consistent with what they're doing. Just because when employees, even though they may be well crafted, they may be carefully put in place, if they're not necessarily applied in the same way, then it's not going to do anything. It's actually going to be detrimental to not only the employment environment, but also any claims that pop up. So inconsistency, that's typically what, like I said earlier, when somebody's looking for some sort of employment claim, say some sort of disparate treatment claim, they're going to be comparing situations. What has an employer done in the past with a specific employee as it relates to a specific infraction? If Billy was late 2 times, but he wasn't fired, and then Bobby was late 2 times and he was fired, if there's then a difference in protected class, maybe one may be older, one may be younger, that leaves somebody to infer that there could have been some sort of discrimination as the basis for why somebody was fired. So the hope is, all right, if we treat everybody consistently, we treat everybody according to the same policies, there's no way for those types of claims to then arise because everybody's been treated the same. And you can't necessarily go through and point to somebody else that they believe was treated differently because of their age, race, gender, whatever. The example I gave earlier about the employee who was maybe treated differently about the self-checkout stand and the perceived theft, there had been several employees in that case who were suspected of theft, but in that case, we had argued that the only one who had complained or engaged in protected activity was actually the only one who was punished. So out of the 41 incidents of theft, the only one who had filed some sort of race discrimination complaint ended up being the one that was fired. And that was a big factor we were looking at to try and argue this guy was fired either in retaliation or based on race-based discrimination. So it's also important to treat employees the same, even though the employees may not necessarily see it that way. Treating employees differently in similar situations can give rise to these disparate treatment claims. I've got a case right now where a total of 8 employees were disciplined as part of an HR investigation. 5 of those 8 were then terminated, and 3 of those employees were suspended. So as you can imagine, the group of 5 is looking, all right, why were we not suspended like the other 3 individuals were? And also so happened that the 5 employees who were terminated fell in some sort of protected class. So the distinction there is those that were fired ended up committing some sort of terminable offense. So they were lying under oath or some other critical policy violation. The other 3 who were suspended is more of a minor infraction, and the employer was able to go through and to specify, here's why we're taking these action towards the 5 employees. Here's why we're suspending these employees. And so they were able to delineate very well exactly why those actions were taken towards some of the employees versus the others. So as part of that, some of those 5 have attempted to argue that there was some sort of inconsistency for trying to equate their behavior with those who were suspended. They seemingly have incorrectly assumed that they engaged in the same behavior as those who were suspended, or at least they tried to paint that picture. However, those 2 groups are not necessarily similarly situated. A court's going to go through and to look at those distinctions there to try and figure out what are the distinctions between the 2 groups, and the level of offenses is actually what a court's going to look at in those cases to determine, all right, the suspended employees didn't necessarily commit the same level of offenses that the other employees who were fired did. So there can't be some sort of claim of race discrimination. Employees are constantly trying to compare themselves to other people. It's important to be aware of that. So by eliminating those inconsistencies, it's important to understand that that they can't necessarily view that as occurring if it doesn't take place. Again, oftentimes employees may think that they're similarly situated to other individuals for purposes of making these comparisons, for purposes of alleging these disparate treatment claims, but they're not always going to be similarly situated. Courts will look at distinguishing factors like levels of severity. They may go through and look at whether or not an employee is a supervisory, has supervisory duties. Somebody in a supervisory capacity is going to be treated differently, and they can be treated differently because they're supervising other employees. I had a case recently where a department head essentially was comparing his own disciplinary infraction to those he was supposed to be supervising. And our argument in that case was that clearly a supervisor can be held to a different or a higher standard because they're a department head. They're charged with supervising these employees. And if those employees under this individual's own supervision was messing up, that's seemingly a red flag in and of itself for that person's supervisory duties. It's also important to understand that even well-intentioned exceptions can be used as evidence of favoritism or bias. There's a concept in litigation known as heightened scrutiny. And so that's where a plaintiff may argue in a retaliation case that an employee may be engaging in some sort of conduct that may be technically objectionable, but it's tolerated by the employer. So what does that mean? So for instance, an employee may be permitted to come into work for a few minutes late without any repercussion, and there's no discipline. However, once the employee potentially requests an accommodation or makes a complaint about discrimination, they then engage in protected activity. And so if the employee then is maybe late a second time after complaining about discrimination or requesting an accommodation, then if that employee is then terminated, they're left to question, all right, what was I terminated because I had filed this complaint, even though I had engaged in some sort of potential policy violation. If it was accepted previously, why is it now viewed differently? And so we've had several plaintiffs make that argument that the employer was engaging in heightened scrutiny, where they were just kind of looking for somebody to mess up after somebody may have made some sort of complaint or engaged in protected activity. So it's important to be consistent, so that way those types of arguments are not able to be made. So again, courts and the EEOC are going to look at, is an employer being consistent? Are they going through and being consistent with their actions and their policies? It's also important to make sure that documentation establishes that if somebody is let go for a policy violation, that it's being applied across the board, the employer is being consistent there. The other kind of underlying thing is being consistent. It's gonna build employee trust. It's gonna reduce those complaints where an employer or when an employee understands its expectations and knows what to expect. That's gonna go a long way. So that way they kind of understand, all right, if I mess up, here's the repercussions and here's what I can expect. Similarly, kind of what I was getting at earlier, the consistency is going to reduce supervisory mistakes by supervisors. When supervisors have a clear and consistent understanding of the expectations policies, they're not going to act impulsively. They're going to know kind of what to expect and what areas to go through and to focus on, as opposed to just choosing to pick on one person versus another. Another good thing about consistency, it's going to go through and strengthen workplace culture. It's going to reinforce those fairness and accountability aspects, making sure that there's positive culture, positive working environment. So consistency is not necessarily just good management, it's good risk management. And the more consistent you're going to be applying those policies and communicating those expectations, and responding to concerns, the stronger you're going to have your foundation for any type of issues that may pop up. Like I mentioned earlier, communication can go a long way in preventing these claims. Oftentimes, there are statements or comments that come up that could have been probably said in a different way that would prevent many of these claims from popping up. Employee comments are often used to support these types of cases, and so miscommunication or misunderstandings often kind of motivate an employee for taking the actions. An employee may think that they're the model employee or the model citizen, and then one day they're let go. So they're obviously been communicated through one way or another, whether through its action or inaction, that they've been kept around for a long time. And once they're let go, then if they've not been given any awareness about that, then they're not necessarily going to think that the reasons they're let go are for valid reasons. So kind of get along the same lines, and there is some overlap here on some of these issues. Communication is going to go through and build trust. And when you've gotten the trust in your employer, it's going to go through and reduce those claims. I've seen this more so recently, but it seems like a lot of employees kind of act as though they are very surprised with actions that are taken. When they are surprised, they look to try and figure out, all right, was I let go for a valid reason or not? And so that usually or sometimes can trigger a complaint where there is an ability to go through and to assert some sort of legal claim. So it's important to have consistent and ongoing feedback just so that way employees are aware of their performance issues well before any formal action is taken. If there's a track record of performance write-ups or some consistent warnings, then people are not necessarily surprised when these actions are taken. So like I mentioned, I have a few cases right now where employees have a new supervisor start working over them. And in each of those cases, the employee had been under the impression that they were performing well simply because they had been in the position for a long time and there not necessarily been any performance write-ups. But when a new supervisor comes in, there's a new set of eyes that may go through and see things differently. They may go through and see that the employee is not necessarily performing up to the expectations for their position, which they should. And because these employees did not necessarily previously receive communication from their former supervisor about performance issues, they're then shocked to learn that somebody else may not see things the same way that they do. And so that can sometimes come about because when an employee or a former employee didn't necessarily understand that their performance was subpar, they look to whatever claim they could potentially assert to assume that's why they lost their job. Was it gender discrimination? Was it retaliation? Similarly, clear communication is going to go through and make sure that those policies are coming across clear. So, I would say one of the biggest issues that we see is just a misunderstanding of policies or how they are applied. And so employees will go through and not necessarily have a full comprehension of what the policies are or why it necessarily applies to them. So that's what they then try to argue down the road. And so communication on the front end can go through and potentially kind of smooth out those issues to where people are on the same page about any type of issues as it relates to leave, harassment, accommodations, anything like that. I would say supervisors' communication is also a very critical aspect for many of these employment claims. Oftentimes, there are comments that are made by supervisors, whether it's in the contents of instituting some sort of adverse employment action or at least managing day to day. And so it's important for supervisors to know maybe how much or how little to say, depending on what's going on. And again, this kind of gets back to that balancing act aspect of just making sure that supervisors are aware of, okay, maybe don't refer to somebody's complaint if they filed a complaint as to why an action is being taken, because that can provide some sort of causal link for somebody to use down the road. Similarly, I had a case somewhat recently to where there was a manager who had gone through and wanted to have a conversation with an 84-year-old employee that was under him. And so I'm sure you can tell where this is going. An age discrimination claim came about, but there had been an 84-year-old employee who's dealing with performance issues for an extended period of time. She was a clerk for kind of an administrative position in a public works type department. And she had failed to properly complete some paperwork. Some things had fallen through the cracks on her end. Problem was she was never written up. There was minimal documentation or communication supporting these issues. And so we ended up having to rely simply on the word of the supervisor. For instance, the employee also had fallen asleep one day during work, but she was permitted to keep working. She wasn't necessarily formally reprimanded. So once the issues became too much, the supervisor had a conversation with her about ending her employment, and he was essentially encouraging her to retire. And according to the employee, the supervisor told her, "You're 84 years old. Don't you think you need to retire and do what you want to do?" Obviously, referencing somebody's age in context of a conversation of where she's being let go or encouraged to retire is not super helpful. So those types of comments can definitely be pitfalls and things to be aware about in terms of communication skills. Obviously, referencing somebody's age in the context of conversation in which they're being let go is not helpful for me down the road to try and defend those type of claims. In that same case, the supervisor apparently, when people would come into the office, he would ask those individuals that didn't know the lady as to guess how old the employee's age was, given the fact she didn't necessarily look her age. And so even though this was not necessarily done to disparage the employee relied upon that in her case to support her age discrimination claim. So that resulted in a significant settlement as a result of that. So I may skip through some of this. Some of this is kind of common sense. Like it's important to have some sort of communication between the employer and employee, just so that way there is an ongoing way to go through and to potentially respond to any issues that pop up. Similarly, it's important to have the communications in these investigations that are ongoing. If there's a complaint that's made, the investigation should go through and delineate what communications were made, who said what, and then also kind of communicating what is found in those investigations to the complaining employees. So that way they have an understanding of what was the action that was taken by the employer. Was there something done to go through to correct an action? So having these communications in the investigation is critical, just going through and outlining what was found and to have these objective sense of what took place. Similarly, tone and timing also matter for these types of issues. It's important to have good tone. Having a condescending attitude or disrespectful message, it's not necessarily going to be well received when somebody's being let go. They're very clearly going to go through and paint the picture that this was a bad guy if this was the tone that the individual received. Like I said, communication is the crux of many of these types of claims that we see, whether it's harassment, retaliation, and it often boils down to an employee's perception of unfair treatment. So one of the other things, kind of the final issue we'll look at is culture. And it's kind of self-evident, but having a positive work culture is going to be one of the best defenses that you have to employment claims. Culture is going to be kind of that first line. If you've got happy employees, they're not necessarily looking to go through and to take any actions. So there's one other case that kind of fits into here. There was a Sixth Circuit case that occurred not too long ago, and I'll probably end up wrapping up in terms of what every employer is trying to promote some sort of good culture. And sometimes an employer can go through and rely upon that culture as a reason to let somebody go. But as I mentioned, there was a Sixth Circuit Court of Appeals case that came out, I think, a couple weeks ago, and it involved a manager at Chili's who'd been fired. and I think he was 59, and he ended up claiming age discrimination. He ended up being replaced by a 33-year-old. But the combination of Chili's and employment law kind of caught my attention. You get the fine cuisine of Chili's and employment law. I'm sure a wonderful combination there. But regardless, in this case, Chili's had asserted that the employee was not living the Chili's way. And that's a pretty bold statement, I guess, to say from a chain restaurant perspective, but that's what they told the guy as to why he was fired. He's not living the Chili's way. He's replaced by, I guess, a 33-year-old who could live the Chili's way. But during the litigation, the court went through and looked at, even though the employer had said that they terminated this individual for culture reasons, court looked to see, all right, what was there some sort of basis for this, or is this just some sort of amorphous term used by the employer to let somebody go? And so Chili's was not able to substantiate kind of what did that mean. So the employee had actually been leading one of the best performing Chili's in that area. And so he really relied upon that to establish maybe I was let go for age discrimination reasons. And that's what the court ended up finding. I'm going to speed through here to wrap up. That being said, it's important to go through and to kind of keep a good culture. Obviously, making sure that employees are happy, keeping happy employees is going to go through, and really it's a marketing technique as well, because you want to have people that want to work for you. Because if you're trying to fill a position, having great culture is going to be much more advantageous than trying to scrape by to have to fill a position. So if you've got a bunch of turnover and a bunch of openings, having a negative culture is not necessarily going to be positive for that. So some final takeaways. I know this is kind of a glimpse into everything, but claims awareness is going to go through and help you to act early and to avoid the escalation. You're going to know what to look for. It's important to be consistent because that can then be used against you if you're not. But it also builds trust and protects against the legal risk in that respect. And then it's important to know that communication is a good frontline defense. So making sure that good, clear, positive communication from those supervisors or whoever else is going to be needed. And then finally, culture is not a bonus, it's a shield. So I will wrap up with that. And if anybody does have any questions, I'm happy to take those. But otherwise, you're also welcome to reach out to me individually. This is my email address. Feel free to reach out, email me. Always happy to go through and to provide any insight to the extent I can.
Awesome. Thank you so much, Ryan. Before we wrap up, any questions from anybody? Last call. Okay. So if there are no questions, please save the date and join us on Wednesday, August 25th for our next Partnering for Success webinar, and it's titled Don't Hire the Perp, Pro Tips for Recruiting the Best and Ensuring the Safety of Your Municipality. And more details will be available in the July edition of Partners News. I hope you all have a great rest of your day, and we'll see you next time.
Thanks, guys.
Thank you.